conflict between international law and domestic law, which law will prevail? Well, there are two theories which answer this question: the monistic theory and the dualist theory. For the monistic theory, domestic law and international law belong to one system. Then on one hand, some monists believe that domestic law is superior to international law, and therefore international law must always give way to domestic law. On the other hand, other monists believe that international law is superior to domestic law, with international law seeking to imbue local sovereigns with a sense of a moral purpose through the universal principles of international law. For the dualist theory, domestic law and international law are essentially different. This is because in terms of the source, domestic law stems from local legislation, while international law comes from the four sources of international law, which we discussed previously. Domestic law and international law also differ in the relations they regulate. Domestic law operates according to sovereign state to citizen relationships, while international law operates according to sovereign state to sovereign state. For dualists, with the clear distinction between the two legal systems and with a strong emphasis on state sovereignty, domestic law is superior to international law. Today, it is the dualist theory which prevails. Article 27 of the Vienna Convention on the Law of Treaties, the treaty which codified the customs about treaties, declares a party may not invoke the provisions of its internal or domestic law as justification for its failure to perform a treaty. Similarly, the International Law Commission, a body established by the UNGA and is made up of legal experts whose opinions are the fourth or subsidiary source of international law, clarifies in its Declaration of Rights and Duties of States that every state has the duty to carry out in good faith its obligations arising from treaties and other sources of international law, and it may not invoke provisions in its constitution or its laws as an excuse for failure to perform this duty. This means that a state may not use its domestic law as justification for its failure to abide by the treaty obligations it consented to, effectively blocking the entry of domestic law into international law. So for example, if a state breaches its obligations to a certain treaty and the other state parties bring that breach to an international court, then the state accused cannot justify its actions by citing its domestic law. Moreover, in the Exchange of Greek and Turkish Populations Advisory Opinion, the PCIJ points to a principle which is self-evident, according to which a state which has contracted a valid international obligation is bound to make in its legislation such modifications as may be necessary to ensure the fulfillment of the obligations undertaken. In simpler words, to avoid conflict between international law and domestic law, states must modify their domestic laws accordingly to meet their international obligations. Nevertheless, international law is not 100% dualist, as it recognizes the general principles of domestic law, the third source of international law which fills its gaps. In the Barcelona traction case of the ICJ, the court declares that international law would lose touch with reality if it would disregard the relevant institutions of domestic law, and thus it should accept rules generally accepted by the domestic systems. In terms of international law in domestic law, the dualist theory still prevails. Thus, most, if not all, states believe that international law has no role in the settlement of domestic disputes or conflicts. Well, unless some rules of international law become part of the domestic law of a state. This usually happens through two approaches: the doctrine of transformation and the doctrine of incorporation. According to the doctrine of transformation, a state makes international law part of its domestic law when it explicitly and specifically transforms a rule of international law into domestic law through the appropriate constitutional machinery, such as an act of Congress or Parliament. Thus, the consent to a treaty is downloaded to the domestic sphere through legislative action. As to the doctrine of incorporation, a state may automatically include or incorporate international law into domestic law, and thus the law of nations is part of the law of the land. Both doctrines are present in the Philippine legal system. For the doctrine of transformation, treaties, the first source of international law, consented to by the Philippines, are transformed and become part of Philippine domestic law through the concurrence of 2/3 of the Senate in accordance to the Constitution, Article 7, Section 21 to be precise. While for the doctrine of incorporation, Article 2, Section 2 of the Constitution specifically expresses that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Thus, the second and third source of international law, customary international law, and the general principles of law as recognized by sovereign states are also treated as domestic law in the Philippines. So, such principles such as the renunciation of war or the use of force, sovereign and diplomatic immunity, universal human rights, and other international law principles are automatically incorporated into Philippine law. If there is a conflict on which law should prevail, whether it's domestic law or international law, it depends on which court the case goes to. If it goes to a domestic court, then domestic law applies. If it goes to an international court, then, well, international law applies. Moreover, again, when a state consents to a treaty, that state is bound to make adjustments to its domestic law so to meet its newly consented international obligations. However, if the conclusion of a treaty fundamentally violates the state's constitution, then the VCLT's Article 46 exception is pointed to, so that the treaty may be invalidated without international repercussions. The constitutional violation, however, has to be manifest if it would be objectively evident to any state conducting itself in the matter in accordance with normal practice and in good faith, meaning that the treaty really violates the state's constitution even if it operates normally and with good intentions. If a state ignores a treaty and cites that that treaty is unconstitutional, but it is found that the conduct of the state does not fit the Article 46 exception, that state can still ignore the treaty domestically but may experience diplomatic scrutiny and international repercussions with international courts and international relations. Again, we cite Article 27 of the VCLT, whereby domestic law may not justify the failure to perform treaty obligations. In terms of domestic court, it is much simpler, as domestic courts are bound to apply domestic law. But for the nth time, remember Article 27 of the VCLT. So this wraps up the short discussion on the relationship between international law and domestic law, and which law will prevail, and the theories and doctrines that apply whenever there are conflicts or debates about the two laws. In the next lesson, we will further discuss how international law is autonomous from both the domestic law perspective and the international relations perspective. See you next lesson.